Hi friends, hope you are all fine. In this video we will discuss this November 2019 CA final new syllabus law paper. So I will just discuss this paper with hint answer. According to me, this paper is very good paper which needs some application of mind with practical exposure. So I cannot say they have asked the repeated questions from say practice manual or straight away taken from any previous year's questions, etc. No, it's absolutely I can say application of mind oriented paper this is. And we'll go now question wise. The first question is procedure for appointing alternate director. They have asked 4 sub questions and each questions carries say 2 marks. So this first A part 1A carries like 8 marks and it goes like this 4 questions. Person can be appointed as alternate director for how many director? So the answer is one person can be alternate director for only one director in the company. And second is if original director participate through video conferencing, whether the original director vote is counted or alternate director vote is counted. So answer is original director as well as alternate directors both vote will be counted because the original director not yet reached India, so he is also valid and here we are also. So both the people will be voting. Sir, how it is possible? Yes, see, alternate director is not a substitute and all. It's like one more director till the original director comes. Okay, we need count. No, we need a count. So if he participate in video conferencing also, that person also will be there and this person also will be there. If in a private limited company, alternate director got appointed and that director is a non-rotational director, can he be there for 3 years period? The original director is a non-rotational director. Whether the alternate director can be there for a period of 3 years. See, in this question we have to answer like this. See, in case if the person is not attending all the board meeting in last 12 months, then that original director has to vacate the office. So at least one meeting he has to participate. So, sir, if he can participate in video conferencing, whether it is amounts to meeting? Yes, because it says like no meeting. It can be even video conferencing. But if this question, it's a very difficult question because we cannot have alternate director like so many period because generally for a period of 1 year only we will do like this. But it's a difficult question. But nowhere it is saying like straight away that this person cannot, because even in alternate director provision it's not said like the tenure is limited to a particular period, because it says the tenure is till the original director comes or the original director retires. Okay, means to come back to India or retire. So original director is not coming back to India for a period of say 3 years, nor he is retiring because he is a non-rotational director, because retirement is not necessary for a private limited company. So typically speaking, if by those 2 provision he has to continue, that is alternate director has to continue. But if all meetings the original director has not participated, then he will be vacating the office after a period of 1 year. Then the fourth question is, can a MD appoint alternate director? See, MD, CEO and all individually cannot appoint alternate director, only the board of directors can appoint alternate director. This fourth question is a well-known question. It's a previous question papers and all there. Then we will go to 1B. AOA of the company restricts contributions to defense fund to the maximum of 5 lakh rupees. First of all, can AOA restrict like this? See, notwithstanding anything contained in the AOA, you can give whatever you want to a defense contribution. This is 183, keep in mind. But AOA is silent on charity and political contribution, and they have given last few years profit, so we have to take only last 3 years average profit we have to take, and we should see the computation part. So political contribution there is no limit, but you have to pass board resolution. Charity contribution you have a limit 5% by passing board resolution, beyond that you have to pass ordinary resolution general meeting. Then the next question 2A. Group of shareholder complained to ROC that some company is doing some unlawful and fraudulent activity. The question is, can ROC do inquiry? If yes, what is the proceedings? Like no, what is the procedure? Can ROC inquire if complaint is withdrawn by the shareholder? Whether central government has a power to direct ROC for investigation or inquiry? This question is straight away from 206. Almost all the subsection they have asked this question. So answer is ROC can do inquiry under section 206. Even central government can ask ROC to do inquiry, and even if the petition is withdrawn, generally the inquiry will continue. This operation mismanagement we have studied. Even if the petition is withdrawn, they will continue this investigation. Then 2B, compromise scheme approved by requisite majority. That means like 75% in value, more than 50% in number. List out the matters to be provided by NCLT in their order. So what are the orders the NCLT can pass generally? Whether conversion of securities is there, variation of rights, then exit option, then creditors rights, whether it is getting affected, then this kind of things. Whether it should be filed with ROC within 30 days of NCLT's order, we have to file it with ROC. Then the next question 2C, company they become NPA, surface notice is sent by bank to the company to settle that entire loan within 60 days. Company objected. Whether the bank has to respond for the objection, can bank enforce the security interest without the intervention of court? This is the question. See, generally bank will send the notice and they will ask to settle within 60 days. This is the bank's rights. Company can raise the objection. That is company's rights. The bank has to respond within 15 days. Okay, within 15 days the bank has to respond. Then can the bank enforce security interest even without intervention of court? Obviously, without intervention of court or NCLT, they have a right to attach the property. But before attaching the property, they should get permission from magistrate. Magistrate alone, they should ask permission. So it's not like court; it's just permission from magistrate. Then 3A. Following companies or foreign companies. Check whether the following companies, whether they are foreign companies. Company registered in Singapore. Their board meeting has happened in India. See, there is no business, there is no share registration or anything, any office. Just they met in India for board meeting. So this is not a foreign company. Thailand company appointed Mr. Y in India to find customers in India to enter into contracts. So Mr. Y is appointed as agent. Hence, we can say Mr. Y is an agent. Hence, Indian business is there. So foreign company, it's a foreign company. So this company is a foreign company. Dubai company maintains server of Indian companies in Dubai. So Dubai company earns revenue from Indian companies. So it's not necessary that server should be in India. Even the main server, if it's in foreign, it's okay. So this is also a foreign company. So this is like my my answer for this question. We have to see, because it's not like it's a totally interpretation based question. We will see once institute is given suggest answers for it. Then 3B, a flat has been purchased from criminal money. Enforcement Directorate people attach the property. Compute the period for the attachment including the extension period. If the person went for stay. See, generally even under PMLA the person can go for stay order. So the time period is generally attachment is 180 days plus stay, then after vacation of the stay another 30 days. So attachment of the property is till this period. So the stay period should be excluded from that 180 days. So 180 days plus stay period plus 30 days. Then can the person enjoy the property? The person whose property is getting attached, can he enjoy the property? Yes, he can enjoy the property. Then can SEBI withdraw the recognition given to the stock exchange? If yes, what is the procedure? Can a member of unrecognized stock exchange perform contracts? SEBI can withdraw the recognition of the stock exchange by giving opportunity of being heard. No person should deal in unrecognized stock exchange, it will become illegal. Then, but when SEBI or central government provides approval, then you can do. Then 4B, company proposed to get listed. Majority of the members of audit committee are financially literate, but no one is expert in finance. See, as per LODR regulations, all the directors in the audit committee should be financially literate, and at least one should have expertise in finance. That means he should be a CA kind of, CA or MBA kind of. Then 4C, as per FCRA, decide the following people whether they can get contribution. Firm gets a loan from a club registered in London. So generally, a firm for the business purpose, they can get loan. That's not an issue. AOP received from foreign company for broadcasting news. Broadcasting news companies or association should not receive anything from abroad. Then marriage gift, somebody has given watch worth of 25,000. See, there are two things. One is relatives, if they give gift up to 1 lakh rupees, no issue. Other than relatives, if you receive gift up to 25,000 rupees, no issue. Then creditors of the company, this is 5A. Creditors of the company filed winding up petition. Workers appealed against it because no, they want to safeguard themselves. Whether the dues of the workers will be settled in priority. This is overriding preferential payments. You should write that 326. Then company wants to buy assets from directors in other than cash. So straight away it's 192. MD of the company appointed a registered valuer. The director purchased this asset 4 years back from a firm where this registered valuer's wife is a partner. So generally we will think what, it's a related party transaction, so registered valuer cannot become registered valuer. See, the registered valuer, if they have directly or indirectly interested in a property in last 3 years, okay, but in this question it's 4 years, it's 48 months, so 4 years, so it's no issue. Then section 192 also you should write like no ordinary resolution has to be passed whenever the company is purchasing a non-cash asset. It means like an asset in a non-cash transaction. Section 5C, can a trade union be a operational creditor under IBC? Can a trade union file as in IBC against a company as an operational creditor? The answer is, if you read the sections, it's not specifically given that trade union can file. So the answer is no per se, but there are Supreme Court judgments in JK Jute Mill case. Okay, JK Jute Mills, even trade unions, okay, can become operational creditors and they can file on behalf of the employees or workmen of the company. Then what is the date of initiation or commencement of IBC? Date of initiation is the day on which the petition is filed, and date of commencement of insolvency is the day on which IRP is appointed. 6A. So 6A, there are two options. So 6A1 and 6A2, that means one of the two you should attend. Small shareholder director, okay, is a SSD in two companies. One is tire company, another one is cotton company. In tire company, they defaulted the deposit payments on July 2018, and even after 1 year they didn't pay it. Whether he has to vacate the office in both the companies. If yes, how many years he is disqualified? See, the question is section 164 subsection 2 clause B. So if you have not paid interest on deposits or redemption of deposits, interest on debentures or redemption of debentures, or declared dividend not paid, you will be given 1 year time for the temporary cash crunch. But your disqualification starts from the day one of the default, but it will take place after 1 year. But the disqualification will be like from the day of default. So it's like 5 years you cannot become director in any other company. You are disqualified for getting appointed and reappointed for next 5 years. Then 6A, the second question. Person is a director of 10 public company and 10 private company. and one dormant company. So it means like 11 private company, out of which one is dormant company. So we can say 10 private company and one dormant company. So that is not an issue, because a person can be director in 20 companies, out of which maximum 10 public companies. So this is okay, and dormant company is excluded. One of the private company is becoming a subsidiary of a public company on June 2019. So that means you are crossing that limit of say the 10. So you have to vacate from one of the public company. Otherwise you will get disqualification under section 164. Then the next question 6b. Director has 2 DINs. He wants to surrender one of that. What is the procedure? So section 155 says you can have only one DIN. We can file DIR 5 with declaration, DIR 6 and affidavit getting notarized. So if you file everything, then ROC will take 1 week time generally to cancel one DIN, and it will be merged with whatever directorship you have in that second DIN. It will be merged with first DIN. So you can ask me, sir, is it not violation having 2 DINs? I have seen persons having 3, 4, 5, 6 DINs. Okay, because every time when someone asks that I want to start a company, the company secretary sometimes previously, not now, like 3-4 years before, they will apply for DIN also. They will not see whether this person is already having directorship in other companies, whether he is having DIN. Sometimes system itself is allotting the DIN previously, not now. See, some people, because of disqualification, their DIN is getting blocked, so they will apply a new DIN, they will file. That has not happened previously, but due to system errors also, some people are having more than a DIN. Some people inadvertently applying DIN. So in today's scenario, after DIR KYC is introduced, it's not possible, but previously it was happening. Then a person bought a car. Okay, person bought a car from a bank loan by a bank loan, and he used for some criminal activity like drug dealing, etc. Then PMLA director catch hold of that person. The car has been attached. So whether PMLA people can attach the car which is already in encumbrance? Answer is, see, once the attachment is made, it is cleansed from all the encumbrance and it will go to the central government without any encumbrance. But there is banker is always having the right to claim the money from that person, the borrower, that is there. Then, can a promoter of the holding company, who is also an insolvency professional, can he be appointed as IRP of the subsidiary company? So the IRP subsidiary company is getting, say, liquidator or anything like that. So subsidiary company, holding company's promoter is getting appointed. So first of all, IRP should be capable of becoming an independent director, and it should be non-related to the company. So in this case, he is a promoter of the holding company, hence he is related, so we cannot appoint him as a IRP. So generally, studying this paper, it's a 70 marks paper, right? Okay. So if you see, there are 2 questions or 3 questions in each chapter, and from directors, we all know directors are the main chapters, directors, meeting and KMP. So here they have not asked anything from KMP. In this 70 marks, they have not asked anything from KMP. But from directors, they have asked questions. The first question itself, like 8 marks question, is from directors. Then again 6th question is from director, another 4 marks. Then again another question 6b is also from directors, another 4 marks. So 8 plus 4 plus 4, almost 16 marks they asked from directors. Then from meetings they asked another 6 marks. Okay, so somewhere around 22 marks they are asking from this 2 chapter. In this attempt they have not asked anything from KMP. So again and again, directors, meetings and KMP are the main syllabus. And IBC related question, I think most of the questions they would have asked in objective type itself, because here if you see IBC question, we have like 2 questions. One is 6 marks question, another one is 3 marks question. So so still IBC also they are asking in descriptive approximately 9 marks they have asked here. So IBC is a second main topic. I don't know how much question they have asked in objective. So even if the objective they have asked, say two questions of 4 marks they asked, then IBC is also weight portion. So what we can say for the next attempt students, like May 20 or November 20, kindly concentrate on directors meetings and KMP, then concentrate on IBC. Okay, then they've asked questions from investigation chapter, compromise chapter. They are mixed with operation mismanagement chapter, state investigation. So operation mismanagement state question they have not asked. They asked question from winding up. They asked question from foreign company. They didn't ask question from NCLT straight, and they didn't ask question from government company straight. Then penalties, I think they have not asked in descriptive. They should have asked in objective type MCQ. They should have asked penalties, special code chapters. Okay, and SEBI SCRA. If you see from economic law point of view, SEBI they have asked only LODR. They have not asked main SEBI. And SCRA they have asked that one question of withdrawal of license. Then PMLA they asked two questions. Okay, PMLA 6 marks question has been asked in 3, and third question 6 marks, and again sixth question another 3 marks. So PMLA is a weight chapter, so it's 9 marks worth and very small chapter. They are giving 9 marks for it. So kindly concentrate on PMLA chapter also. Then arbitration they have not asked in this paper at all. November 2019 they have not asked arbitration. They have asked FCRA. Excuse me. So they have asked FCRA. So maybe next time we can expect question from arbitration. Maybe they would have asked arbitration in MCQ also. So hope you understood something from this video. Thank you all. Bye.